Good afternoon, ladies and gentlemen. Thank you for being here. This is an open meeting on the 4th of June, 2025 of the United States Securities and Exchange Commission under the Government and the Sunshine Act. Commissioners Caroline Crenshaw and Mark Ueda are here with me in Washington, and Commissioner Hester Peirce is participating remotely. Today, the Commission will consider a recommendation from the Division of Corporation Finance that the Commission issue a concept release seeking comment on whether to revise the definition of foreign private issuer. The Commission first defined foreign private issuer in 1967. Then in 1983, it developed a foundation of the current definition through a test to determine whether a foreign issuer is, quote, essentially a U.S. issuer, unquote, based on a percentage of U.S. ownership, the nationality of the management team, the location, and the location of business operations. The world in financial markets and corporate legal structures have significantly changed over the last 40 plus years. The United States capital markets have been and still are the envy of the world. Foreign companies from around the globe seek new capital from U.S. investors for their businesses and seek to have their securities listed on a U.S. exchange for a variety of potential benefits, including higher valuation, greater liquidity, and enhanced reputation. Foreign companies that qualify as foreign private issuers receive these potential benefits while also being offered several accommodations under the federal securities laws that are not available to U.S. companies. These include provisions such as, one, not needing to file quarterly reports, proxy statements, or Section 16 reports. Second, not being subject to Reg FD. And third, furnishing current reports on Form 6K rather than filing the more prescriptive Form 8K. As early as 1935, the Commission recognized that our rules should not treat foreign companies exactly the same as domestic companies, likely because many aspects of their corporate operations, business and market practices, accounting standards, tax regimes, compensation and pension benefits, and organic corporate governance laws may be quite different from those in the United States. Yet at the same time, the Commission always has been mindful of the paramount need for the adequacy of disclosures provided by foreign companies to their U.S. investors whenever it considered new accommodations under the federal securities laws for these companies. When the Commission provided foreign companies with additional regulatory relief in 1967, it noted, quote, the improvement in the reporting of financial information by foreign issuers resulting from changes in foreign corporate laws, stock exchange requirements, and voluntary disclosure by the companies themselves. Today, maintaining reasonable accommodations in the federal securities laws to attract foreign companies to U.S. markets and to provide U.S. investors with the opportunity to trade in those companies under U.S. laws and regulations remains an objective of the Commission. That objective must be balanced with other considerations, including providing investors with material information about these foreign companies, including their unique corporate structures, and ensuring that domestic companies are not competitively disadvantaged with respect to regulatory requirements. The first step in striking this balance is to determine which foreign companies should qualify as foreign private issuers and be able to avail themselves of these accommodations. It has been several decades since the Commission last examined the characteristics of the foreign private issuer community. The global markets have changed significantly in those decades. It is therefore only prudent for the Commission to understand better the companies that are using the foreign private issuer accommodations today and determine if changes are needed to better protect U.S. investors. Based on the latest data from 2023, for example, almost 55% of foreign private issuers are traded exclusively or nearly exclusively in the United States. Among these issuers, the most common jurisdiction of incorporation is the Cayman Islands, and the most common jurisdiction of headquarters of these companies is China. When the United States is effectively a foreign company's exclusive or primary trading market, and the company is not subject to meaningful disclosure requirements or securities law oversight in its jurisdiction of incorporation or headquarters, careful consideration should be given as to whether the foreign company is eligible for accommodations under the federal securities laws that are unavailable to United States companies. This analysis begins with considering whether the current definition of a foreign private issuer is appropriately tailored. The concept release solicits public input on this issue, and I encourage market participants to submit their views and engage with my office and the commissioner's offices on this topic. Before I turn the meeting over to Cicely Lamoth, Acting Director of the Division of Corporation Finance, to discuss the recommendation, I should like to thank the following staff members for their work on this concept release. So first, from the Division of Corporation Finance, Cicely Lamoth, Sebastian Gomez Albero, Ted Yu, Michael Coco, Kelsey Glover, Katerina Kuntsevich, Mark Green, Ryan Milne, Wei Liu, Heather Rosenberger, Kayla Roberts, Anna Abramson, and John Fieldsend. From the Division of Economic and Risk Analysis, Lyndon Orton, Matthias Nilsson, Evan Avila, Tara Bandari, and Timothy Dodd. I should like especially to recognize Matthias and Evan because the data in their white paper on trends in the foreign private issuer population significantly contributed to this concept release. From the Office of International Affairs, Kathleen Hutchinson, Matthew Greiner, Morgan McDonald, Michael Ferrario, Jordan Spain, and Katerina Osanova. From the Office of General Counsel, Jeffrey Fennell, Bryant Morris, Johanna Lozert, Mike Killoy, and Cynthia Bien. From the Office of Chief Accountant, Ryan Wolf, Shaz Nizai, Nigel James, Chauncey Martin, Maikoi Wentan, Jill Davis, Sarah Esquivel, and Ella Carfiat. So now I turn the meeting over to Cicely for the staff's recommendation.
Thank you, Chairman Atkins and Commissioners. Today, the Division of Corporation Finance is recommending the Commission issue a concept release seeking the definition of foreign private issuer under the federal securities laws. I will provide a brief overview of the concept release, and then I will turn it over to Kelsey Glover in our Office of International Corporate Finance to provide more detailed descriptions. Over the years, the Commission has sought to provide foreign issuers with regulatory flexibilities that preserve access for U.S. investors to such issuer securities while maintaining appropriate investor protections. Foreign issuers that qualify for foreign private issuer status under the federal securities laws benefit from accommodations that provide either full or partial relief from requirements for domestic issuers. Since the Commission last amended the definition of a foreign private issuer, or FPI, much has changed in the global regulatory and business landscape. We recommend today that the Commission issue this concept release to seek input on the FPI definition and consider whether the definition is appropriately tailored for today's global markets. As part of the staff's preparation of this release, we have undertaken a broad review of the issuers that currently rely on FPI accommodations and have really considered the rationale for the current definition. The staff's research, as well as our experience overseeing filings from the FPI population, have informed the discussion and questions that are raised in the release. This concept release is the result of hard work and coordinated efforts from staff throughout the agency. I would like to thank all the members of the team that worked on this release, and in particular, our colleagues in the Division of Economic and Risk Analysis and in the Office of International Affairs, whose assistance was instrumental to this release. And now, I will turn it over to Kelsey Glover to present more detailed information about the concept release. Kelsey?
Thank you, Cicely. Good afternoon, Chairman Atkins and Commissioners. Today we present for the Commission's consideration a concept release seeking input on the definition of foreign private issuer. or FPI. As global markets evolve, the Commission periodically assesses whether the FPI regulatory framework continues to appropriately serve U.S. investors and U.S. capital markets. A recent broad review by the Commission staff of FPIs that are subject to reporting obligations under Section 13A or Section 15D of the Exchange Act shows significant changes in that population since 2003. Because the changes indicate that the current FPI population may no longer reflect the issuers that the Commission intended to benefit from FPI accommodations, we are recommending that the Commission issue the concept release to solicit comments on whether the FPI definition should be amended. The concept release would provide an overview of the FPI definition and regulatory framework. Additionally, the release would outline some of the recent developments that the staff has observed in the FPI population following its broad review of the FPIs who have filed annual reports on Form 20F from fiscal year 2003 through fiscal year 2023. The staff chose 2003 to begin its review because it was the first year FPIs were required to file electronically on EDGAR. These developments include changes in the total number of reporting FPIs and in their jurisdictions of incorporation and headquarters. The staff's review also shows that the majority of FPIs filing annual reports on Form 20F have their equity securities traded almost exclusively in the U.S. capital markets. Finally, the release would discuss potential concerns about these developments and solicit comments on whether and how the current FPI definition might be revised to address those concerns. The release would present several potential regulatory approaches for consideration, including updating the existing FPI eligibility criteria, implementing a requirement that FPIs have a percentage of their equity securities trading in a foreign market, implementing a requirement that FPIs be listed on a major foreign exchange, implementing a requirement that FPIs be incorporated or headquartered in a jurisdiction that the Commission has determined to have a robust regulatory and oversight framework, developing new systems of mutual recognition, and implementing a requirement that FPIs be incorporated or headquartered in a jurisdiction that has signed onto a specific international cooperation agreement. The release would solicit public input on each potential regulatory approach, as well as on the FPI definition generally and the anticipated outcomes of any proposed changes. We would be happy to answer any questions.
Well, thank you all very much. So let me turn now to my fellow commissioners for their statements and questions. So remotely, Commissioner Peirce.
Thank you, Mr. Chairman, and thank you to Cicely and Kelsey and to the staff for your efforts on this concept release. The questions we're posing are timely and appropriate. The Commission formally adopted rules meant to accommodate foreign companies attempting to register securities in the U.S. 90 years ago. The decision then was sensible. After all, American investors should not be prohibited from investing in good companies because our laws make selling to Americans more trouble than it's worth. Since that initial recognition of the peculiar circumstances of foreign companies in 1935, our rules from time to time have changed how foreign companies are regulated in the United States. One of the animating principles behind some of our past rulemakings has been the notion that various accommodations and relief from domestic rules are appropriate because foreign companies are subject to meaningful regulation and disclosure obligations in their home jurisdictions. Our role as market regulators is not simply to make new rules, but to evaluate old rules to ensure that they're still effective and appropriate in light of new developments. In the nearly 20 years since our last examination of the foreign private issuer regulatory framework in 2008, a lot has changed. Among the things that have changed is the composition of 20F foreign private issuers. Back in 2003, 20F foreign private issuers were predominantly incorporated and headquartered in Canada, our neighbor to the north. Fast forward to 2023, and the picture looks a bit different. The Cayman Islands and China are now the preferred location of incorporation and headquarters, respectively. Additionally, we've been trending further toward a world in which foreign private issuers trade almost exclusively in the United States. Digging a little deeper into that trend, we see that companies that do trade almost exclusively in the United States have a higher propensity of being incorporated in the Cayman Islands and headquartered in China. Those observations address only a portion of what has changed since our last evaluation of the foreign private issuer framework. Today, the Commission is asking a broader fundamental question. Have the changes in the characteristics of the foreign issuers that choose to access our capital markets contravene the policy rationales and objectives that have made our foreign private issuer regime into what it is today. The concept release puts forward potential solutions, some better than others, along with a series of questions that will help the Commission assess their respective merits. A particularly weak solution that the Commission is considering today asks whether a foreign private issuer should be required to be incorporated or headquartered in and subject to the oversight of the signatory authority of a jurisdiction in which the Foreign Securities Authority has signed the IOSCO Multilateral Memorandum of Understanding concerning consultation, cooperation, and the exchange of information. That the answer is no. Neither the MMOU nor the EMMOU does anything to ensure that American investors have access to the material disclosure that is an essential part of our regulatory regime. With that reality in mind, the Commission concedes from the beginning that such a solution would likely function as a complement to other regulatory responses. So why would we choose to adopt as a potentially unnecessary sidecar requirement a solution that does nothing to provide investors with material information while simultaneously ceding regulatory authority to an international organization? Were this solution to be adopted, we could lose control of the FPI definition altogether, as IOSCO could unilaterally increase the commitments it required. Despite my reservations, I believe that we are asking the right questions, and I want to thank the staff again for your thoughtful examination of this issue. This concept release is a welcome return to a data-driven approach to rulemaking, and I look forward to hearing from the public. I do have two questions for the staff. First, what are we planning to do to make sure that FPIs in their countries of domicile and incorporation are aware of this concept release?
Thank you for that question, Commissioner Peirce. So the staff has formulated a plan to reach out to FPIs and their advisors, as well as foreign regulators and key international organizations such as IOSCO and FSB. As you know, CorpFin regularly meets with representatives of FPIs, such as bar associations, major legal law firms, advising FPIs and other groups that might be focused on FPI matters. We will also be reaching out to them to alert them of the concept release. In addition, CorpFin staff regularly speaks at major conferences with a large number of FPI attendees, and we will discuss the concept release in order to increase awareness. Our colleagues in OIA will similarly reach out to their foreign counterparts in jurisdictions with large FPI populations, as well as key IOSCO and FSB subcommittees to inform them of the concept release and the issues that are raised in the release. Kathleen, are there any particular additional thoughts that you have that I might have missed?
No, you covered it. Thank you, Cicely.
Okay, so I do think that we will expect the first outreach that we have to occur shortly after Commission approval of the release.
Okay, that's wonderful. I'm glad you have such a detailed plan. And then if we were to move forward with a change, what kind of transition period would you envision recommending?
Right. So the Commission, of course, would ultimately consider the need for a transition period as part of any formal rulemaking that might arise from the concept release. So I would not want to get ahead of the Commission on that decision right now. But having said that, the staff recognizes the significant changes that would result from foreign companies that lost their FPI status. The inability to rely upon certain FPI accommodations, such as the ability to provide IFRS financial statements instead of U.S. GAAP financial statements, as well as some of the exemptions from Section 16 reporting and U.S. proxy rules, could require considerable adjustments to a company's internal processes and practices that will take time to implement. That being said, I do want to point out that the concept release does solicit feedback on this important question. If the Commission decides to proceed with a rule proposal, we expect that it would solicit additional public comment on the need for transition period and the necessary length of time. The staff would then consider this feedback carefully when formulating any final rule recommendations for the Commission.
Okay, that's very helpful. Thank you. I don't have any additional questions.
Thank you.
Commissioner Crenshaw.
Good afternoon. Today we put out questions to industry participants around our framework for allowing foreign private issuers access to our markets. It's been nearly 2 decades, as you've heard, since we last visited this topic, and I agree that it's time for us to reconsider those rules. Now, if you'll indulge me, this may sound a bit repetitive of what my colleagues have already said at this point, but the framework that we have in place is premised on the expectation that foreign issuers seeking access to our markets will be subject to meaningful disclosure and oversight in their home jurisdictions. But the data posited by staff calls those assumptions into question. The markets have changed, and we must too. So I'm happy to see us putting out this release. I approach this issue with certain principal questions in mind. Does our framework for allowing foreign private issuers access to our capital markets provide adequate disclosure to and protection for American investors? Are we providing advantages to foreign issuers by giving them access to our markets at a proverbial discount, thereby disadvantaging domestic issuers, particularly smaller U.S. companies, who abide by the full complement of our rules? And, as a corollary, what are the costs to U.S. companies and U.S. investors as a result of these policy choices? At bottom, I think we need to have a robust but level playing field. Unfortunately, as the release sets out, there are some potentially troubling data on the landscape as it exists today. First, as you've heard, among the set of reporting foreign private issuers, the data show that their home country jurisdictions are very different than they were 20 years ago. According to the staff's data, as of 2023, the largest jurisdiction measured by issuer incorporation is the Cayman Islands, and the largest jurisdiction by issuer headquarters is China. In 2003, as Commissioner Peirce noted, Canada, which we have recognized as having a robust regulatory regime, was the most prominent jurisdiction for foreign private issuers, both in terms of incorporation and headquarters. Prior to the 2003 amendments, the overwhelming majority of foreign private issuers were European in origin and subject to the oversight by their domestic regulator. Second, we're seeing more issuers that have headquarters in one place, again, more prominently China, and then incorporate in another place, most prominently the Cayman Islands. And third, over half of the 20F filers trade exclusively on the U.S. markets and not in their home country or other markets. Where companies are not trading in their home markets, they may not be subject to the rigorous disclosure or regulatory regimes that the Commission had in mind when it erected this framework. The data appear to paint a picture of regulatory forum shopping. Companies seem to be setting up headquarters in one country, perhaps based on the location of the founders, cheap labor, resources, extradition laws, or other reasons, then seeking incorporation in a separate country, which may provide diminished oversight, disclosure, or reporting requirements, and then finally coming to the U.S. to satiate their capital needs. We allow these companies, in large part Chinese companies incorporated in the Caymans, the benefit of our markets, regardless of whether their home rules provide the meaningful transparency and accountability that had been historically envisioned in connection with our foreign issuer framework. We should not unwittingly allow our markets to be part of an international regulatory loophole at the expense of U.S. investors and U.S. businesses. To that end, I'm pleased that the staff has put together this concept release that asks important questions about whether our current definition of foreign private issuer is sufficiently robust to provide necessary disclosures, protect investors, and preserve market integrity in light of the current landscape. We're asking a lot of the right questions, and I hope market participants of all stripes will carry the mantle in response. But I also wonder if we should look beyond just the definition of foreign private issuer itself and revisit whether the actual securities law exemptions offered to foreign issuers are fit for purpose today. The release lists over 20 exemptions or accommodations offered to foreign private issuers. Among them, as you've heard, reporting foreign private issuers are not required to file quarterly reports, whereas our domestic U.S. issuers file reports quarterly on Form 10-Q. They're subject to potentially more lenient current reporting requirements than those required of the domestic issuers on our Form 8-K. They're exempt from Reg blackout trading restrictions, and they're exempt from obligations under Section 16, and the list goes on. But isn't it worth revisiting this list? Has the scale tipped too far in terms of relieving foreign private issuers of important reporting and integrity obligations? Take the Section 16 example. While corporate insiders of U.S. public issuers are required to publicly disclose their trades electronically within 2 days on Form 4, insiders of foreign private issuers do not have the same reporting obligations. Recent bipartisan legislation and studies have put on display the inequities around trading among insiders at foreign private issuers, which show opportunistic trading resulting in significant loss avoidance by foreign insiders. This appears to be the case especially in connection with foreign insiders in certain non-extradition countries, such as China and Russia. Why are U.S. insiders held to account for insider trading when it appears foreign insiders may do so with impunity? This does not seem to me to be the correct policy result. One way to make sure that we're preserving market integrity and providing U.S. investors with material information about their investments is to, ourselves, ensure through our rules that all who seek to benefit from our markets do so under equal obligations with equal accountability. That is our responsibility and obligation. It is worth revisiting not only the definition of foreign private issuer, but also the long list of carve-outs bestowed upon foreign companies seeking access to our markets. Thank you to the staff in the Division of Corporation Finance, the Division of Economic and Risk Analysis, the Office of International Affairs, the Office of the Chief Accountant, and the Office of the General Counsel, as well as to the offices of the Chairman, my fellow commissioners, and all who contributed to this release. Thank you to the IT team and all who assisted in the operations behind today's meeting, and I look forward to hearing the feedback from all industry participants. Thank you.
Well, thank you, Commissioner Ueda.
Well, thank you, Chairman Atkins, and thank you to the SEC staff for your presentation. Also say thank you to the Office of the Secretary and Office of Support Operations. I think by my count that since the onset of COVID, this may be only the fourth open meeting that we've had in the auditorium since 2020. So I know it's a lot of work to get everything back together. And it's great to be back here. For today's concept release, one central issue that underpins it is whether and to what extent the substance and frequency of disclosure by foreign issuers should differ from U.S. issuers when raising capital in the United States. How do we promote capital formation for companies and investment opportunities for investors while minimizing the likelihood that foreign competitors might leverage regulatory vacuums to obtain a competitive advantage over U.S. peers? Today's concept release contains extensive data with respect to foreign private issuers and how the universe of such companies has changed over the last 2 decades. As a proponent of database policymaking, I find the work of the SEC economists and data analysts helpful, and I'm very happy that that data and their work is included in the concept release. Such data analysis provides a good reason to reassess the foreign private issuer definition and the current regulatory regime. It's been nearly a half-century since the Commission last considered this question. The core requirements of the federal securities laws are based on the obligation of securities issuers to provide timely financial information and other material disclosures. In a similar vein, it's also important that SEC regulations remain timely and relevant. I'm pleased that today's concept release attempts to address these core capital markets issues. About a year ago, I suggested that to mitigate the confusion and inconsistency caused by recent SEC rulemakings with respect to private foreign issuer disclosure, that the agency should consider publishing its views in a white paper or concept release and soliciting public feedback on what principles should guide future rulemakings with respect to foreign private issuers. Today, I'm very happy that we are following through on that suggestion. I hope that the concept release will provide sufficient public comment on whether the Commission should revise its foreign private issuer regulatory framework, one that does not elevate legal form over economic substance. Companies that qualify for foreign private issuer status benefit from accommodations that provide full or partial relief from domestic issuer disclosure requirements. This framework recognizes that foreign private issuers are subject to disclosure practices in their home jurisdictions while maintaining regulatory standards that align with U.S. federal securities laws. Balancing these considerations requires evaluations of market data and a comparative look at foreign regulatory requirements. In adopting Form 20F in 1979, the Commission stated that U.S. investors in foreign securities should be supplied with information equal, as nearly as possible, and practicable to that provided to investors in securities of domestic issuers. However, as the agency also stated at that same time, the examination of securities regulation in international markets should be continuing and evolutionary. Staff in the Division of Economic and Risk Analysis, the Office of International Corporate Finance, and the Office of International Affairs have analyzed market data and legal requirements to inform the discussion in this concept release with a view to rethinking the regulatory framework for U.S. investors and foreign issuers that are traded in U.S. capital markets. A recent DERA study on the subject noted that foreign private issuers are increasingly relying on the U.S. securities markets for the trading of their equity securities in more recent years, which contrasts with the notion that foreign private issuers generally have their equity securities cross-listed on a foreign stock exchange. One potential impact of this trend is whether foreign private issuers are subject to equivalent disclosure rules in other jurisdictions. There may be less information about Form 20F, foreign private issuers being made available to U.S. investors than in the past due to the FPI disclosure accommodations and their interaction with home country requirements. This trend may increase investment risks for U.S. investors and may also create unfair competitive advantages. It may also interfere in price discovery and reduce the potential benefits of the efficient markets hypothesis. These are areas of significant regulatory concern. Investment risks due to materially incomplete disclosure runs counter to the fundamental purpose behind the U.S. securities laws. Further, unfair competitive advantages create artificial barriers to capital formations for the companies that are negatively impacted by such advantages, whether they be non-FPIs or other foreign private issuers. Any regulatory answer to the questions in today's concept release should be based on ensuring that the SEC's treatment of foreign issuers reflects today's global capital markets and does not place U.S. companies at a competitive disadvantage or deprive U.S. investors from receiving appropriate disclosure. Informational asymmetries can increase investment risk and raise the cost of capital to compensate for such risk. Notwithstanding these concerns, it's important to note that we have not to date seen large-scale market failures from the differing disclosure regimes for U.S. issuers and foreign private issuers. To the extent that there have been issues with respect to foreign private issuers, they often involve outright fraud and material misstatements and omissions. In other words, fraud can occur irrespective of the form that the issuer files or the exemption on which the issuer relies on. In balancing investor protection considerations, we should be mindful that U.S. investors benefit from the ability to diversify their holdings through ownership of foreign securities. I look forward to hearing the public's thoughts on this issue, the views and experiences of both investors and market professionals. Today's efforts are another step in getting us off in the right direction. Effective rulemaking is developed by actively engaging with the public. We have an opportunity to improve and modernize our regulatory framework by enhancing the quality of FPI disclosure and considering what rules our regulatory regime should apply to such companies. So I want to thank the staff in the Division of Corporation Finance, the Division of Economic and Risk Analysis, the Office of International Affairs, the Office of the General Counsel, and the many other offices that have contributed to this concept release. I know the chairman read off a list of names of the staff, but I would also add one other person who is on loan to the chairman's office from the Office of International Corporation Finance, Gabe Eckstein, who's now serving as your chief of staff. But I do know that in the past year, prior to coming up to the 10th floor, he was heavily involved in this efforts to analyze foreign private issuers. So shout out to him. But thank you for all of your hard work and your expertise. It benefits our capital markets. It benefits our U.S. investors. I don't have any questions.
Well, thank you, Commissioner Ueda. I thought I might point out a couple of things here. So one, I really salute you all in the work that you've done on this. And it's kind of, Commissioner Peirce pointed out, and Commissioner Ueda as well, and Crenshaw that, the last time we addressed this issue was back in 2008 when we revised the departure rules around that and, made some other adjustments to foreign private issuer reporting. So I happened to be voting on that too, way back when. So it's how things come around, and the more they change, the more they stay the same, I think. But anyway, it's thank you very much for your work, and so this is. I think you've done a very good job. And this, as the public will see when you look at this release, it's chock-a-block with data. And so thank you to Court Finn and our economists and others who may have contributed to the tables and the data that's in here. I think it's very impressive and should be food for thought for people out there, and hopefully that'll elicit other sorts of submissions. So a couple of points I just maybe wanted to discuss here. The relationship with Canada, of course, has been a long one now, and very close, and with our MJDS. And we've had inquiries over the years from other countries who may seem to be interested in mutual recognition or something along those lines. But I was wondering, Cicely or Kathleen or whoever may want to answer this, but what's our experience been with MJDS? I assume, by the number of companies from Canada, it's still, high, and obviously it's a border there that is long and, with operations on both sides. And so how has that kind of been here over the last now 3 decades, I guess?
So I'll start, and then I'll turn it over to either Ted Yu, who might have some thoughts, and then we can turn it over to Kathleen for her perspective from OIA. I think it's been a long and fruitful process to get to the MJDS situation that we have with Canada. I think that was a long deliberative process to get to that point, but it has worked well, and I think that we've continued to find ways to engage with them on a number of issues as they've arisen over the years. But Ted might be able to provide some additional feedback there.
Sure, thanks, Cicely. The MJDX process is something that, like Cicely mentioned, has worked well generally. This concept release does solicit comments on expanding the idea of mutual recognition to other countries as well. It does know the use of MJDS and the Commission's effort to establish that decades ago. It's something that we're interested in hearing from folks as to whether or not we should apply it in other situations as well. And maybe I'll turn it off to Kathleen. We've been talking to, who can maybe share it with some of the Canadian regulators' thoughts on this.
Thanks. I agree with Cicely and Ted that it's been a very positive experience. We have a long and robust cooperation relationship with Canadian authorities in all of the provinces, and we speak with them frequently and have found the partnership to be quite effective. They are also signatories to our enforcement MOUs, and we have a very robust cooperative relationship under those arrangements.
Good. Well, yes. Well, thank you. So that's been my impression as well from the outside looking in, and so I'm glad to hear that as well. So, lest people think out there that this is a product of xenophobia or something like that we're coming out here, I think that's completely not it. And obviously, as we have been emphasizing here, and staff as well, that we're still in active outreach, and we still welcome foreign investment in the United States and foreign companies coming here, and which is an important aspect. And and I think that's the government as a whole has obviously, that's been in the news here recently as far as inbound investments. So we're about to encourage that, and that's what our capital markets are for capital formation. So with that, thank you all again very much for your work. Do the commissioners have any other questions, or Commissioner Peirce?
No other questions.
Okay, all right. Well, thank you very much. So do the commissioners vote to approve the Division of Corporation Finance's recommendation to issue the concept release on foreign private issuer eligibility?
Yes.
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 And yes. So the recommendation is unanimously approved and by a vote of 4-0, of course. So that concludes the business on today's agenda, and so the meeting is adjourned. Thank you very much.